Hello everyone, how are you all? I hope everyone is keeping fine and safe. Yes, so let's start our video today. As you see, we are discussing about the various concepts relating to law, that's legal reasoning. So there will be discussions relating to law. I'll give you various topics and definitely we will be discussing a very special topic here today, which is called the law of torts. Okay, you might have heard about law of torts in your syllabus or it must be included in an examination. So what is this all about? What is exactly the law of torts that we are going to discuss here today? There are various laws, but law of tort is a very important one, which we are going to start. Law of tort. It is a branch of law which has evolved through judicial pronouncements. The origin of the word tort and its meaning is very important. The term tort has been derived from the Latin term tortum, which means to twist. It basically refers to a conduct which is not upright or lawful. In French, the term tort refers to a wrong. Now, what is the definition of tort? Tort is a civil wrong which is redressable by an action for unliquidated damages and which is other than a mere breach of contract or just a breach of trust. So, how do we determine that a particular wrong is tort or not? Thus, when a wrongful act is done, firstly we have to examine whether it is civil or criminal wrong. If the wrong is a civil one, we have to find out if the breach of contract or the breach of trust is done or not. If it does not belong to either of the category, that's either it's neither breach of contract nor breach of trust, it can be concluded that it is a tort. Now there are few elements of tort. Firstly, wrongful act plus legal damage. So wrongful act is the first element and legal damage is the second element. So what is wrongful act? Wrongful act is an act or an omission. When a person is made liable for a tort, he must have either done an act which he ought not to have done. You can take examples of publishing a defamatory article about a person or anything else, or has omitted to do that which he ought to have done. Okay, you have failed to take a reasonable care of your committed work, or if you have been engrossing in negligence. Okay, so if you consider the example of municipal corporation omits to close a sewage tank on the road and fail to display a warning to be aware of, right? So that can be done. The second element I told you, apart from the wrongful one, was legal damage. Okay. So legal damage means violation of a legal right. To succeed in an action for a tort, the plaintiff has to prove that his legal right has been violated. Now, since we are talking of violations, I'll say you there are two types of violations: injura sine damnum and damnum sine injura. Let's see what it is. The first one, that is injuria sine damnum. This means this maximum means violation of a legal right without causing any damage or loss to the plaintiff. This is a situation where the defendant has done a wrongful act or omission, as the consequence of which the plaintiff has not suffered any loss or damage, except that his legal right has been violated. This is a fit case for an action under tort, and the defendant is held liable. Coming to the second one. The second type of violation I told you was damnum sine injuria. Just the reverse. The literal meaning of this maxim is that damage has been caused without violation of the plaintiff's legal rights. Just the opposite I told you. Damage has been caused without violation of plaintiff's legal rights. This is a situation where a defendant has done an act. As a consequence, the plaintiff suffers a loss, but the act in question does not violate the plaintiff's legal right. The first one was a case where violation of a legal right was done without causing any damage, and the second one is just the opposite, which means damage has been caused without violation of the plaintiff's legal rights. That's the difference. Now, there are few things which are more to be discussed. That's the general defenses available against torts committed. When the plaintiff brings an action against the defendant for a tort, the defendant on his part can avoid his liability by taking the plea of any one of the defenses that I'm going to say right now. Voluntary non-fit injuria. What does this mean? It literally means that if a person voluntarily subjects him to some risk, he cannot later complain as his consent serves as a good defense against him. Let's take an example. Let's take Santosh. Santosh is playing volleyball with his friends in a playground. He is hit by a ball on his eye and bleeds profusely. In this case, Santosh can sue any one of the present in the playground as he voluntarily exposed himself to take any risk. Is it so? No. He cannot sue anyone or anybody in the playground as he himself went to the playground to play. And he himself is exposed to any risk that the game would expose him. So it cannot be sued. There are definitely exceptions to it. First exception, there are two exceptions, rescue cases and Workmen's Compensation Act. In rescue cases, when the plaintiff voluntarily undertakes a risk to rescue somebody from an imminent danger created by the wrongful act of a defendant, the defendant cannot set up the defense of voluntary non-fit injuria against the plaintiff. The second one I told you is Workmen's Compensation Act. This we have heard of previously. An employer cannot escape from the liability arising out of his negligence in ensuring the employee's safety. He cannot set up the defense of voluntary non-fit injury. Next, firstly, we have discussed voluntary non-fit injuria. The second one we are going to discuss is inevitable accident. If the plaintiff has an unexpected injury owing to the unforeseen and inevitable event, in spite of reasonable care on the part of the defendant, it is called inevitable accident. The defendant has to prove that he neither intended to injure the plaintiff nor had the means to avoid the injury by taking reasonable care. The third act we are going to discuss is Act of God. Act of God refers to some natural calamity. We can take examples of heavy rainfall, storm, earthquakes, volcanoes, etc. Two conditions which are very essential for this defense is, firstly, there must be working on natural forces. Secondly, the occurrence must be extraordinary and not the one which could have been anticipated or thought of before. Okay. The fourth one we are going to discuss is private defense. One can protect one's person or property by using reasonable force. However, the use of force is justified only for the purpose of defense. And in the process of self-defense, if any harm is caused, the defendant is not liable. Now, there are two important features regarding this. Firstly, there should be imminent threat to personal safety or property. And second one, the force should be reasonable. Okay. Now we will discuss about vicarious liability or vicarious liability, strict liability, and absolute liability. Okay? So these are the three types of liability which we often make mistake or we have confusion regarding this. So we are going to discuss. So firstly, the term vicarious liability means liability of a person for the tort committed by someone else. Vicarious liability arises in the cases that I'm going to say right now. Three cases. Firstly, the liability of the master for the tort or his servant. Secondly, liability of a partner for each other's tort. Liability of the principal for the tort of his agent. So these are the three types of tort these the three types of vicarious liability we have. Principal and agent. Let's come to this discussion. When a person appoints another to do any act for him or represent him in dealing with third person, just to bind himself by the act of such person, such a person is called the principal. An agent is a person employed to do any act for another or to represent another in dealing with a third person. Thus, an agent establishes a link between such another person and the third person. Now, there are a few general rules also regarding this. Firstly, general rules for laws of agency. There are two rules. Firstly, quid facit per alium facit per se. What does this mean? Sounds to be quite hard, but it's not so. This maxim literally means that an act of the agent or the act of the agent is the act of the principal. The principal is liable for all the acts done by the agent during the course of agency. And the second one we have is whatever a principal can do himself, he may get the same done through the agent except acts of personal nature. Moving to the next one, that is master and servant. If a servant does a wrongful act in the course of his employment, the master is liable along with the servant. Thus, the wrongful act of the servant is deemed to be the act of the master as well. This is based on the doctrine of respondent superior, that the principal be liable. Okay. And there are a few conditions also for the liability of the master. Again, two conditions which I'm going to discuss. Firstly, the tort must have been committed by the servant. And secondly, the servant must have been committed the tort in the course of his employment. The liability of the master is not limited only to the acts which he expressly authorizes to be done, but he is also liable for torts committed by his servant on his own accord and in the course of the employment. That is, in the course of the employment of the servant. Okay. Now we'll discuss liabilities of the master for different types of torts committed by the servant. Firstly, fraud of servant. When a servant, while in course of performance of his duties, commits a fraud, the master would be liable for the same. Okay, for the same performance. Secondly, theft by servant. If a servant steals goods entrusted to his master, the master is liable to the plaintiff. Thirdly, mistake of the servant. Where a servant acting on behalf of his master makes a mistake, causing loss to the plaintiff, the master will be liable for the same. Next, negligence of the servant. If the servant acts negligently in the performance of his duties or displays reckless behavior, thereby causing loss to the plaintiff, the master would be liable for the same. And fifthly, wrongful delegation of duties. If a servant negligently delegates his authority and allows to be performed by another person, the master will be liable for such negligence of the subject. That's of the servant. So we have 5 cases: fraud of servant, theft by servant, mistake of servant, negligence of servant, and wrongful delegation of duties. Next, we are going to discuss non-liability of the master for the acts of the servant. In case where loss or damage arises without the actual fault or knowledge of the master, the servant does the act in defiance of express prohibition and act is outside the course of the employment. Effect of express prohibition laid down by the master. Sometimes the employer may forbid his servant from doing certain acts. If the servant does the act in defiance of the prohibition, it does not mean that the act is outside the scope of employment. Thus, the master is still liable for such acts provided the act is done in the scope of the employment. Where the service of the servant is temporarily lent to another person, master may not be liable for the acts of the servant if the temporary master exercises control and superintendence of all the servant. Coming to the next discussion, that is liability of the employer for the acts of an independent contractor. For independent contractor, generally the employer is not liable for the torts committed by an independent contractor employed by him because that's independent or he or she is independent. However, this rule has got some exceptions where an employer can be made liable for the wrongs of the independent contractor. There are 3 exceptions which we are going to discuss. Firstly, if an employer authorizes the doing of an illegal act. Secondly, the employer's liability arises for the dangers caused or near the highway. An employer is liable for the act of an independent contractor in case of strict liability. Next, we'll discuss vicarious liability of the state. According to Article 300 of the Indian Constitution, the Union of India and the states can sue and can be sued. However, under what circumstances that can be done is not clearly stated. So a number of High Court and Supreme Court judgments, it appears that the court holds the state liable for torts committed by its servant only in the exercise of non-sovereign functions. In the exercise of sovereign functions, the state cannot be made liable for the tortious acts committed by the servant. Now we'll move on to doctrine of strict liability and absolute liability. Okay, I just mentioned the name previously. Now we are going to have a thorough discussion. Now, what is doctrine of strict liability? In some cases, a person or a defendant is liable for the harm caused to another person, that's the plaintiff, even though there is no negligence on the part and he never intended to make such a harm or to come to other person and make this harm. In such cases, even the defense of inevitable accident is not a valid defense. This is known as principle of strict liability. The principle was laid down in the famous case Rylance versus Fletcher. This rule is applicable when harm is caused by the escape of fumes, gas, electricity, wild animals, etc. Essential ingredients for the application of doctrine of strict liability are there are actually 4 which I'm going to discuss. Firstly, a person on his land must have brought some dangerous thing. Secondly, the thing thus brought or kept by the person on his land has escaped. Thirdly, that means the thing that he has brought has escaped. Thirdly, it must be a non-natural use of land. And fourthly, it should have been a dangerous thing. In order to make a defendant liable, it must be proved that he had kept on his land a dangerous thing. That is a thing likely to cause harm if it escapes. There are two scenarios in that case. One is escape, and the second one is non-natural use of land. So when we are talking of escape, to apply the doctrine of strict liability, the dangerous thing kept on land should escape from the defendant's land. For example, if there is projection of the branches of a poisonous tree on the neighbor's land, this amounts to an escape, and if the cattle lawfully enters on the neighbor's land are poisoned by eating the leaves of the same, the defendant will be held liable under the rule. Next, I'm going to talk about non-natural use of land. Non-natural use refers to some special use by the defendant which may otherwise expose others to increased danger. Water collected in the reservoir is such a huge quantity in Rylands versus Fletcher was held to be non-natural use of land. Also, there are exceptions to the rule. Firstly, act of God. Let's consider the example. Number one, act of God. The dangerous things escapes due to unforeseen or supernatural forces without any human intervention. The defense of act of God can be pleaded. Second, consent of the plaintiff. The rule of law where there is consent and there is no injury is applicable where the plaintiff has consented to the accumulation of the dangerous thing on the defendant's land. He cannot sue if it escapes and causes some damage. The third one, plaintiff's own fault. Where the thing escapes due to the plaintiff's own default and cause damage, the rule in Ryland versus Fletcher does not apply. Number four, wrongful acts of the third party. If the harm caused is due to the act of a stranger who is in no way under the control of the defendant is not liable under the rule. Okay. Now we are going to talk about the doctrine of absolute liability. See, the doctrine of absolute liability is the creation of the Supreme Court in preference to the rule of strict liability according to Rylands versus Fletcher. The highlight of the rule is of absolute liability is that it is not subject to any of the exceptions discussed under the rule of strict liability. This path-breaking decision was made by the Supreme Court following two major gas leaks, namely the escape of methyl isocyanide from the Union Carbide plant, that's the Bhopal gas tragedy, and the leakage of oleum gas from one of the units of Sriram Foods and Fertilizers Industries, that is MC Mehta versus Union of India. As the first case wreaked havoc on thousands of innocent lives, the Supreme Court feared that industries dealing with hazardous substances would escape their liability for damage caused by leakage of deadly gases by pleading some exceptions under the doctrine of strict liability. Hence, the courts in India are in favor of applying the rule of doctrine of absolute liability instead of doctrine of strict liability. So this was a discussion relating to torts. Yes, torts is not completed yet because torts is a huge topic that needs to be covered. In the next video, we are going to continue with torts. Do keep watching that. And the previous videos have already been discussed relating to torts or some others also. What are law? What are the types of law? All the definitions and differences have been discussed. So you can follow them also if you require. In the next video, we are going to have the continuation of torts. So thank you. All the best for your career. And thank you for watching this video.